Hello, listeners. This is part 3. A great deal of your time will be spent on disciplinary issues. They can be long and difficult process, but very rewarding at the same time. The very first thing you need to do is educate your members about their Weingarten rights. So let's go over that in a little more detail. Whenever a member is asked to talk with a supervisor and they believe the discussion could lead to disciplinary action, they have the right to have a union steward or other representatives attend the meeting. The United States Supreme Court has ruled that you have the right to refuse to answer any questions until the union steward is there, but you have a right to first discuss the issue with the union steward. This right includes if you are called on the phone. Once the steward arrives, you are required to answer the questions truthfully. The supervisor does not have to tell you of these rights. You must invoke these rights for yourself. Once you have asked for a steward, management must stop questioning. If they fail to stop, they are in violation of the law. If they try to pressure you into answering questions, this is also a violation of the law. You do not have the right to have a steward at every meeting, but if you have a reasonable belief that the meeting can result in you being disciplined, then you have every right to have a steward being in attendance. Preparing for a disciplinary case is not much different than preparing for a grievance. Disciplinary actions can result from violation of company's rules or policies and procedures. Poor job performance, absenteeism, insubordination, or inappropriate behavior at work. Credibility is huge in disciplinary hearing and grievances based on disciplinary actions. The case must be built so that if it goes to arbitration, the neutral arbitrator will believe the union side of the issue. As in all cases, you need to make sure to check the story from every aspect. Have them repeat the incident repeatedly and question every aspect of it. Explain to the member that you are doing this just as the company will so that he is prepared. Interview all witnesses, including any management that may have been involved. Get the employee's personnel records. This will provide you with information about previous disciplinary actions he or she was involved in. If you can't get these records prior to the hearing, ask for a postponement. Make sure that the records are accurate. If expired documentation exists in the file, request it to be removed. You need to verify what the contract and the company's policy and procedures manual say in regard to the alleged violation. Remember that if there is a violation, the fight is not over. The rule must be known and there may be mitigating circumstances. Lastly, you must look to see if other coworkers have done the same thing or worse and not been disciplined or received a lighter penalty. Discipline cannot be discriminatory or arbitrary. The nature and procedures of disciplinary hearings are governed by law, contracts, and our procedures. In general, the steward should follow these guidelines at a hearing. 1. Speak to the members prior to the hearing. If it is a formal disciplinary hearing with a notice, check the notice and proceed with an investigation of the alleged infraction. If you are called in at the last minute, seek a postponement so that you can make a proper investigation. If the meeting is informal, make sure the member has time to talk with you ahead of time or take a recess to get some understanding as to what happened. 2. Prior to the hearing, inform the member who will be present how the meeting will be conducted and what he or she should expect. 3. Get as much information as you can beforehand. Do not let the employer withhold information. If they do, speak to your local union. Document any denials of information in writing and get it on the record. 4. If there are any witnesses at the meeting or hearing, you should question them as you see fit. In most formal hearings, the process of questioning the company's witness is called cross-examination. You have a right to ask these witnesses questions to determine the accuracy of their testimony and their biases. Your rights to questioning should not be interfered with by management. If you are denied that right, make sure that such denial is entered on the record. 5. It is perfectly proper for members to answer questions with yes, no, or I don't know. Once the member has answered a question, he or she is under no obligation to elaborate. 6. At most hearings, the steward can take as active a role as he or she sees fit. 7. You can stop the meeting at any time to speak privately with a member. 8. Take notes or bring in a second person to take notes. 9. Do not rely on the supervisor's notes. The written record is important. It documents what actually was said, not what was allegedly said. Cases have been won and lost on the accuracy of the record. The bottom line is to make sure that the member is treated as fairly as possible under circumstances that are heavily weighted against him or her. You must handle all discipline as if the case will go to arbitration. Remember, if the investigation does not go the way you hoped, you can challenge the discipline. How management conducted itself through the process are the just clause section of your contract by appealing through your grievance procedure. One of the most difficult to defend disciplinary action is for insubordination. Many contracts have the language that an employee can be disciplined and are discharged for insubordination. Insubordination will be dealt with quickly, harshly, and with little to no forgiveness. Arbitrators have, for the most part, dealt with insubordination, ruling that you should obey now, grieve later. Insubordination is usually defined as the failure or refusal by an employee to perform a task or comply with an order given to him or her by a supervisor. Usually this order will have to be reasonable and basic to the conduct of the employer's business. This is such a serious issue that insubordination is considered a terminal offense. Let us consider some issues that will affect the results of the insubordination in a disciplinary hearing. Some people work in very noisy work environments, so the order would have to be heard before insubordination could be considered. Was the order clear? Could the member have misunderstood what the supervisor meant? Was the member given an order, or was it instruction, suggestions, or advice? Did the supervisor give the member a warning of the consequences for failing to comply with the order? Was the order a reasonable order? Was the order that the member thought would endanger himself, herself, or his or her coworkers? The Occupational Safety and Health Act, OSHA, provides for employees to refuse to follow an order that is dangerous. If the work is unsafe, the employee must report it and ask that it be made safe, not just refuse to do the work. The other side of this is that the order should be reasonable and necessary to the safe, orderly, and efficient operation of the business. It should not violate the contract, work rules, past practices, past arbitration decisions, or the law. Was the member aware that he or she was being given a direct order? Was the member provoked by the supervisor? Was there an ongoing dispute between the supervisor and the member? Could the member been set up by a supervisor who had previous conflicts with the member? Most important, did the insubordination occur when the member was performing a duty for the union as an officer, representative, or steward in the union? Remember, the steward, officer, representative, acting as such, is protected and considered equal when performing the duties of their union position. Remember and educate your members that it is best to obey any order than grieve it later. There are a lot of labor laws on the books, but probably the most important one is the National Labor Relations Act of 1935. Before this act, employers could freely interrogate, fire, discipline, and even spy on employees. During the Great Depression, workers went on strike, battled police and security forces. The NLRA forbids employers from discriminating against workers who join unions, exercise leadership, or engage in strikes. The NLRA has 41 sections. The most important are sections 7, 8, and 9. Stripped to its essentials, Section 7 reads, employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid and protection. Section 8A defines employer violations. These are known as unfair labor practices, or ULPSs. 5 types of conduct are prohibited: interference, restraint, or coercion directed against union or other collective activities, Section 8A1. Creation or domination of a labor organization, Section 8A2. Discrimination against employers to discourage support for a union, Section 8A3. Retaliation for filing ULP charges are cooperating with the NLRB, Section 8A4. Refusal to bargain in good faith with union representatives, Section 8A5. And interference in union activities violate Section 8A1. Discharge and suspensions violate Section 8A1 and 3. Unilateral changes, refusals to supply information, and denials of union assistance during investigatory interviews violate Section 8A1 and 5. Section 8B prescribes union unfair labor practices, including unfair representation, bargaining in bad faith, and secondary picketing. Section 9 sets out procedures for union certification and elections. The National Labor Relations Board enforces the NLRA. The NLRB has 52 regional and sub-regional offices. A 5-person board heads the NLRB. The President of the United States, with Senate consent, appoints board members to staggered 5-year terms. One member's term expires each year. The President also appoints a general counsel who is in charge of prosecuting unfair labor practices. ULP charges. Union attorneys, officers, and stewards can file unfair labor practices charges. The charge must be filed within 6 months of the event or conduct that forms the basis of the charge. Charge forms can be requested from the NLRB office or downloaded from the NLRB website, www.nlrb.gov. A ULP charge can be handwritten or typed. The easiest method is to fill it in on the NLRB website, print and sign it. Then mail, fax, or hand deliver the charge to the regional office with jurisdiction over the worksite. The NLRB will serve a copy on your employer. The union should do this itself if near the end of the 6-month limitation period. Investigations. Board agents investigate ULP charges by interviewing witnesses and reviewing documents. When the investigation is complete, the agent and his supervisor make a recommendation to the regional director to issue a complaint, defer or dismiss the charges. Complaint. If the regional director concludes that a complaint is warranted, the board agent will inform the employer and attempt to bring about a settlement. If these efforts fail, a complaint will issue and the matter will go to a hearing before an administrative law judge, ALJ. An NLRB attorney will prosecute. The ALJ can order the employer to cease its illegal conduct, make up for any harm, and post a notice promising not to commit further violations. The ALJ cannot impose imprisonment or issue a fine. The employer or the union or both appeal an ALJ decision to the 5-member board in Washington. Further appeals can be taken to U.S. Circuit Court and the U.S. Supreme Court. Deferral to arbitration. Under a policy called deferral, regional directors hold up investigations of ULP charges if the matter appears resolvable under the parties' grievance and arbitration procedure. The NLRB justifies a deferral as a way of conserving resources. Unions contend that a policy takes away their right to have ULPs rectified by the NLRB and forces them to incur arbitration expenses for matters that may not be covered by the contract. The NLRB applies its deferral policy to most ULPs by employers that occur while a contract is in effect. The following are exceptions. 1. Refusal to furnish requested information. 2. Violations of Weingarten rights. 3. Retaliation against employees for filing NLRB charges. Deferral may also be withheld if the deadline for a grievance has expired and the employer refuses to allow a late filing. If the employer has exhibited hostility to the grievances and arbitration process, or if animosity between the union and the agreement could affect the union's handling of a matter. Despite the likelihood that a regional director will defer, there are several reasons to file ULP charges. 4. The NLRB's preliminary investigation may induce the employer to rectify the violation. 5. If the charge is deferred, the union grieves and the case is taken to arbitration, the arbitrator will be more likely to apply NLRA precedent when deciding the matter. 6. If the arbitrator rules against the grievance, The union can ask the regional director to revoke for a reopen ULP investigation and issue a complaint. Dismissal. In addition to the lack of merit, a regional director can dismiss a ULP charge because the violation is technical, minor, or if limited duration, and no other meritorious ULP charges have been filed against the employer for the past several years. Wow, this is a lot of information to take in at one time. I would suggest you download the PDF file of this document. You can also use it as a reference when you have a question or are not sure of what to do in a situation. Just keep the following items in mind and you will do fine. 1. Keep yourself informed on union affairs. 2. Serve as an example to your members. 3. Keep the members informed on union policies and union activities. 4. Attend union meetings and union affairs. Encourage and bring the members from your department. Don't chide members for missing meetings. Think of other ways to communicate with them. 5. Meet the new members early. Inform them, educate them, and help them become members. Make them more than dues payers. 6. Get your location to act as a union. Have them stick together. 7. Act as a leader. Do not let personal likes or dislikes prejudice your actions as a grievance representative. 8. Fight discrimination, whether it be overt or very discreet. Discourage prejudice of any kind. 9. Keep accurate and up-to-date records. Write it down. 10. Do not promise if you cannot deliver. 11. Encourage political action on the part of your members. 12. See to it that they are registered and vote. 13. Be active politically. Encourage members to exercise their rights to vote and to vote for labor-friendly candidates. 14. Know how to refer to the union contract, bylaws, and international constitutions. If you are not sure, seek help so that you can become familiar with the documents. 15. Encourage and support the union activities on behalf of organizing the unorganized. 16. Inform the membership of union services. Encourage them to take advantage of not only the services the union sponsors outright, but those that the union helps subsidize. If your local does not already have a community service representative, encourage the local to create one. 17. Fight whenever you meet it, the anti-union element. You can best do this by being informed and being dedicated to the labor movement. 18. Do not hesitate or stall. If you do not know, admit you do not know, and then try to get the answer. 19. Keep your workers informed on sources of information. Give pertinent information whenever a worker wants it. 20. In dealing with the management, remember that you are the elected or appointed representative of your fellow members. Never consider yourself to be inferior to your management representatives. You are always their equal. 20. Be proud of your position. Remember, you are a union representative of your local union, which has the full support of members bound together in an international union, with the support of millions of other union members. 22. Wear your union bun and encourage your coworkers to wear it. 23. Investigate every grievance it were your own. Keep the member informed. Make sure you keep your deadlines. There is no excuse for missing a time limit. Research every grievance as if it were going to arbitration, but try to resolve it at the lowest possible level. Keep your local union informed of the status of each grievance. 24. Attend and encourage attendance at any labor education program that might be available to you and your members. 25. Remember your goal is to be the best union representative you can be. Always strive for this goal. Excellence has no substitution. Now you have a good idea of what being a steward is about. What you need to do is study up on. You know your contract. You know what to do in disciplinary meetings. You have studied what to do when approached with a grievance, how to investigate it, and how to handle a grievance hearing. So relax a little. You need to remember to take time out for yourself every so often. Now get out there and start performing like a rock star. And to wrap this one up, I'd like to thank our sponsor, the National League of Justice and Security Professionals, where the members come first.